warahmatullahi wabarakatuh.
Yes. Yes, Dr. Farooq, can you hear me?
Yeah, I can hear you now.
Okay, we start the session now. Bismillah ar-Rahman ar-Rahim. Alhamdulillahi Rabbil Alameen. Wassalatu wassalamu ala nabi al-amin wa ala alihi wa sahbihi ajma'een. Wattabi'ina lahum bi ihsanin ila yawmiddin amma ba'd. Distinguished guests, lecturers, instructors, students, my dear brothers and sisters. نادي الاقتصاد الإسلامي بجامعة الكويت Islamic Economics Association would like to welcome you all to today's session, Sharia Supervision of Islamic Financial Institutions, Issues and Challenges. This is a part of our weekly lectures, our events and arrangements to promote Sharia standard, Sharia mechanism, Sharia compliant models. And as you know, we are conducting lectures, trainings and workshops and seminars on different topics and various types of areas we are covering through these activities of the International Islamic Economics Association. And today we do have our guest speaker, Dr. Muhammad Faruk Abdulla, who is currently a senior lecturer at the School of Banking and Finance Management, Faculty of Business and Management, University Sultan Zainul Abidin, Malaysia. And Dr. Farooq obtained his bachelor in Sharia and Usul Fiqh from the International Islamic University, Malaysia. And then he did his master's from INSIF, Global Center for Islamic Finance in Malaysia. And Dr. Farooq achieved his PhD, Doctor of Philosophy from the University of Malaya. And currently he is working as a senior lecturer at the Sultan Zainul Abidin University in Malaysia. And Dr. Farooq is a familiar to us and with all of us, as he is continuously conducting and giving lectures and conducting trainings under the Islamic Economics Association. So this is our honor to have our guest speaker, Dr. Muhammad Faruk Abdullah, today to conduct another lecture on Sharia Supervision of Islamic Financial Institutions, Issues and Challenges. So I welcome Dr. Muhammad Faruk Abdullah, and I actually have sent our slides, modified slides, to Dr. Farooq. I think you can also present from the slides that I sent to you.
Okay.
Okay, thank you very much, Dr. Farooq. Please welcome.
Assalamu alaikum wa rahmatullahi wa barakatuh, and good afternoon to all. Alhamdulillahi Rabbil Alameen, wassalatu wassalamu ala nabiyil amin wa ala alihi wa sahbihi ajma'in. Rabbi shrah li sadri wa yassir li amri wa hlul uqdatan min lisani yafqahu qawli. Allahumma la sahla illa ma ja'altahu sahla wa anta taj'alul huzna idha syi'ta sahla bi rahmatika ya arhamar rahimin. Amin ya rabbal alamin. So first of all, I would like to thank the Nadi al-Iqtisad al-Islami, the Islamic Economic Association based in the University of Kuwait, for again inviting me. I feel honored to be here, and I think it is my fourth lecture, and also in this platform. And also I thank Dr. Muhammad Mahiuddin for moderating this session and for introducing me. And also thank you to all the participants. And I welcome all of you. So inshallah today I'll be talking on a very important issue, which I would say the heart of Islamic finance is called Sharia supervision. It is something on through which the Islamic financial institutions they make sure they are following the Sharia, which is their ultimate objective. So inshallah, I'll be talking on some of the start from the basic of these Islamic governance principles. And then inshallah, I'll be sharing with you some of what is the current practice, and then what are the issues and challenges in this topic. So let me share with you my slide. I have a slide. Okay, can you see my slide, Dr. Mahiuddin? Could you please?
Yes, yes, it's visible. Yes.
All right, thank you. So, as you see, the topic is Sharia supervision of Islamic financial institutions, issues and challenges. So, Sharia Islamic financial institutions, mostly we mean Islamic banks and takaful. And maybe I'll cover also some of the Sharia supervision related to like Sukup and as well as Islamic mutual fund that might be covered. And my discussion will be on starting, I'll go a little bit on the background of Sharia supervision. I'll start with the Islamic corporate governance principles and the theories. And then I'll come to the Sharia supervision. What is the current practice? What are the roles and responsibilities of the Sharia scholars or Sharia advisors, their qualifications, and then what are the issues and challenges that the industry is facing right now. And some of the examples, so maybe I'll bring from my experience from Malaysia as well as from the global perspective from the Middle East and also from the Islamic finance in the non-Muslim countries as well. So if we look back to before this Sharia supervision is about the corporate governance. As we know, this the corporate governance it is based on a very basic principle of this agency and principal relationship, where even in a conventional sense, in the modern day corporations where the shareholders, they do not manage the company, and their corporations, they appoint their agents who like the CEO and CFO, they manage the company. So from that comes the issue of agency problem, where how to make sure that the agents, they are working for the best interest of the shareholders. So from that comes the principle of corporate governance and the mechanism, and so there are different models. Well, so from that also we have the Islamic perspective of corporate governance, where in order for a company, a corporation or financial institutions, in order to make sure that they also work for the best interest of the shareholders, as well as they are also making sure that there is Sharia compliancy, there is no violation of the Sharia and others. So these Islamic corporate governance principles, this is a set of organizational arrangement on how a corporation is directed, is managed and governed and controlled, and they are monitored, so that there is always a check and balance. And this provides the governance structure through which all the stakeholder interests are protected, the company's objectives are achieved, and the principle of Sharia are complied with. So the objective of Islamic corporate governance is to make sure that all the stakeholders' interests are protected, as we learn from the Maqasid al-Sharia, that the Islamic Sharia always advocates the communal prosperity, the development of the Muslim community. So we need to look from a different perspective, where that a corporation can fulfill the interests of the community, as well as there is a Sharia compliance in every steps or every arrangement or every process or system of the corporation. Now, so which are the institutions or organizations that are looking at this? There are basically three for the Islamic financial institutions. The first is the Accounting and Auditing Organization for Islamic Financial Institutions, which is based in Bahrain. From the very beginning of the development of modern day Islamic finance, they have been developing the standards for the accounting principles, as well as for the governance principles, how the standards in order to make sure there is proper Sharia supervision, there is proper Sharia monitoring, and also there is proper procedures in terms of the Sharia-based products or contracts. Similarly, IFSB, which is Islamic Financial Services Board based in Malaysia, they are also focusing on the governance principles. They are very concerned on how to make sure the Islamic financial institutions, they are governed in such a way that it is effective and there is robustness, and there is stability in the system. So they are working more on the governance principles, or we can say IFSB as the Basel Committee for the Islamic financial institutions, that is working on the how developing the governance standards, principles for the Islamic financial institutions, and also for the regulators, in order to make sure the Islamic financial institutions are they are stable in terms of governance. And there is another institution called Al-Hawkamah, the Institute for Corporate Governance. Well, this is a regional institutions. It is developing corporate governance standards, and also solving issues and problems among the corporate issues. Mostly it is based in the Middle East. So Hawkamah institutions coverage is among the countries in the Middle East. And then of course there are central banks. They are also giving standards, as well as policy documents in order to make sure there is proper Sharia governance and Sharia supervision. So going back to this theoretical foundation of this Islamic corporate governance, that how an Islamic financial institution or Islamic corporation can be governed, how they should be supervised, and how they should be managed. So in order to understand the Islamic corporate governance, let's look at what's the conventional model of the corporate governance. So there are two model that is very famous in corporate governance. One is the Anglo-Saxon model, another one is the European model. So according to the Anglo-Saxon model, which is based on UK and US, they are, which is also advocates the capitalist system. Well, based on this model, the board of the directors or the management, they should work for the best interest of the shareholders. So they have the managers or the board of the directors, they have a kind of fiduciary duty in order to make sure that they work for the best interest of their shareholders. So they mostly, their objective is to maximize the profit for the shareholders. Of course, they have some kind of CSR activities, but their main concern is to maximize the profit for the shareholders, and that's it. And their objective is to gain profit. While in the European model, they also have two boards, where one is the board of the directors, another is the Sharia Supervisory Board. According to their philosophy, that a corporation is not only works for the shareholders, rather it also works for the society. So they have two boards. One is the board of the directors that works on behalf of the shareholders to maximize the profit, to fulfill their interests. But there is another board, which is called the supervisory board, that will make sure that the other stakeholders of the company, their interests also are protected. Means what is the impact of the corporation on the society, and so they also have trade unions and worker councils, and they also have an influence in the management, where and the supervisory board, they'll make sure that the companies is fulfilling the stakeholders, all the stakeholders' interests, and it is fair to all, even though they also they have an objective to maximize to the profit for the shareholders. However, for the Islamic corporate governance model, which is actually a theoretical model that was developed few years ago by Chaudhry and Haq. So according to them, they proposed that Islamic corporate governance model, it should be based on Tawheed, which is that we are ultimately responsible to God, Allah subhanahu wa ta'ala, and whatever the wealth is we have been given, it is by Allah subhanahu wa ta'ala as a trust, so that we can maximize its utility in order to achieve falah or success in the hereafter. So according to this model, it is based on this concept of Tawheed, where there should be a Sharia board that will be on top of that. So that will make sure, along with also the board of the directors. So there should be a Sharia board that will also practice the concept of shura, or mutual consultation, and it will make sure that all the stakeholders' rights are protected, and the Sharia principles are followed, whatever in the company's operations, there is no violation of the Sharia principles, as well as the community's interest is also protected. As we know, the Sharia, based on the Maqasid Sharia, as we know that Islamic Sharia also advocates that the societies should be developed, there is the community should be prospered. So the corporation also should contribute to the social well-being of the community. So this is a holistic model where it, of course, making profit is a concern, but at the same time, it also, the Sharia board will make sure there is no violation of the Sharia, as well as there is a shura based model. There is shura in the consultation in the management. At the same time, it is fulfilling the rights of all the stakeholders and working for the social well-being of the community. Well, even though this model is criticized, or some still feel doubt whether it is possible to implement, however, it may not be implemented as it is, but it is partially implemented, or at least it gives us the idea for the best practice, that which way we should go forward. So based on that, if we look at the Sharia governance, so when we say that Sharia governance principles or Sharia governance of financial institutions, so this is what the IFSB has defined, that when we talk about Sharia governance, so it is actually a set of institutional and organizational arrangements through which an Islamic financial institution ensures that there is effective independent oversight of Sharia compliance over each of the following structures and process. So when you talk about Sharia governance for any financial institution, it means that there is Sharia compliancy and there is also independent oversight. There is monitoring by the independent body that these are the four processes. This is the four arrangement. There is oversight or monitoring by an independent body. First, in terms of the issuance of relevant Sharia regulations. So where how the Sharia regulations related to financial transactions are given. So how they are issued. Second is that the dissemination of information of Sharia regulation to the operative personnel of the Islamic financial institution. Means the resolution, or we can say it as fatwa, is not enough. How that fatwa is disseminated in among the different parts or the departments of the Islamic financial institutions. So if there is a fatwa which is related to the, for example, the treasury department of the financial institution or the risk management department, so how it is disseminated and how it is implemented. And then number 3 is also an internal Sharia compliance review or audit. So there should be an audit and check and balance, as we know, based on the concept of hisbah, that in the history of Islam there was always al-hisbah practice in the Islamic caliphate, as well as in the Islamic markets. So there should be always a monitoring. So audit is playing that role of hisbah, that and to have a check and balance whether there is any violation in any part. And also there should be an annual Sharia compliance review. So along with the review and audit, regular audit, there should be an annual Sharia compliance review or audit that and then the Sharia advisors, they will publish whether there is any violation, whether there is any non-Sharia compliance income, and whether that income is purified. So from that Sharia governance part comes the Sharia supervision. So what is this Sharia supervision? It is just to make sure, to ensure that the financial institution is running based on the principles of the Sharia. So it is ensuring the extent to which the operations of the Islamic financial institution, means it is the company, the takaful or Islamic bank, they conform to the provision of Islamic law or the principles of the Sharia, and with the in accordance of the fatwas issued, means the resolution or the fatwa issued by the Sharia scholars and the decision approved by the fatwa authority, means that whether the fatwa is approved by the higher authority of that country. So Sharia supervision is on monitoring as well as giving advisory services or consultancy, or giving rulings related to any Sharia matter, whether that needs any ruling. At the same time, also monitoring that the Sharia principles are followed. So basically, if we now look at now let us look at the practice of this Sharia supervision. We just learned about Sharia governance model, how a company should be governed based on the Sharia. So if we look now around the world, and if we see how the Sharia supervision are done in different financial institutions, so we can actually find there are 3 types of supervision model. One is a regulated centralized framework. Another one is the regulated decentralized framework. Another one is unregulated. So what is the regulated centralized framework? The regulated centralized framework is that there is a central Sharia supervisory committee at the country or the national level, and there is a law for the operation of the Islamic financial institutions, and also there is also supervision at the institutional level. Means that every Islamic financial institution has his own Sharia supervisor. At the same time, there is a Sharia Supervisory Council at the national level, and there is a law that gives them support, or that there is a law that actually gives what should be the procedures for the operation of the Sharia supervision. So the example of this regulated and centralized framework can be two countries so far I have found, which is Malaysia and Indonesia, where they have a centralized framework. At the same time, they are regulated, means that there is a government law that makes sure the financial institutions, they follow what the Sharia advisors give advice. If they violate the Sharia advisors recommendation or the resolutions, there will be severe punishment that is stated in the law. And there are some countries whether they have regulated decentralized framework, means that these countries, there is a law, the government provides law, and the Islamic financial institutions, they should follow the resolution and then of the Sharia advisors, and if they do not follow, there is a punishment or whatsoever. But there is no central Sharia supervisory board, means that there is only one layer or one level of Sharia supervision. So the example can be, for example, is the Dubai or the UAE. So they have regulated. There is a law, but they do not have a centralized Sharia supervision. In the case of like Kuwait and Qatar, and they also have central Sharia supervision, but it is not that regulated. Means that the law said that if there is any issue in the institutional level, if there is any conflict among the Sharia advisors, then they may refer to the National Sharia Advisory Council, and that Sharia Advisory Council is not dedicated for Islamic finance. Rather, they are under the Ministry of Waqaf and Islamic Affairs. Same with Kuwait, means, for example, in Kuwait, they have Sharia advisor for every institution, Islamic financial institution. And if in case there is any issue, so there is a conflict among the Sharia advisors, they can brought the issue to the Sharia advisors at the Ministry of Waqaf and Islamic Affairs. However, there is no robust, or there is no active management or oversee from the Sharia Supervisory Board of the Awqaf and Islamic Affairs Department to oversee the operation of Islamic financial institutions. So that is regulated, but it's quite a decentralized framework. And then the number 3 is the unregulated framework, means that this is a framework where there is no legal support from the government. The government did not give any regulation, or there is no regulatory authority that actually pushes the financial institutions to have Sharia supervision. Okay, so these financial institutions, they do have Sharia advisors, but that is because of the market forces. Because in order to gain access or to get confidence from the mass, from the public, from the depositors, they do have Sharia supervision, but they are not really required by the central authority or the central bank. And the example of this, mostly the non-Muslim countries like in Europe, and even in the Saudi Arabia, they also do not have any regulation actually for the Islamic banks to have Sharia supervisors. Rather, it is just a market force. So this is also an example of an unregulated industry. So mostly the non-Muslim countries in the Britain and in Singapore, they do not have a strong regulation for the Islamic financial institutions to have Sharia advisors. Even in case of Bangladesh also, it is not compulsory for Islamic financial institutions to have Sharia supervisory board, but they do it because of the market forces in order to gain confidence. However, this actually practice lead to a lot of issues in the Islamic financial institutions when there is no regulation. And when the Sharia advisors resolution is not compulsory, so it gives opportunity to the financial institutions to overlook some of the resolutions of the Sharia advisors, and that actually created a lot of issues in the Sharia supervision. I'll elaborate further on this. There, as I said, we have found 3 different models, and what is the most recommended Sharia supervision model? So based on my reading, that I would say this is the model which is most recommended by the scholars, that in order to have the proper Sharia supervision. So there should be a regulator, there should be a proper regulation from the central bank or the central financial authority that will force and also that will supervise the Sharia supervision of the Islamic financial institution. And there should be a National Sharia Advisory Council, and that National Sharia Advisory Council should work together with the Sharia advisors for Islamic financial institutions. So there should be 2 Sharia board. One is the Sharia board for each individual Islamic financial institution, and there should be a National Sharia Supervisory Board at the national level, at the central bank, and they should work together. Means that the National Sharia Advisory Council should have good communication and proper monitoring and also observation on the activities of the Sharia advisors of the Islamic financial institutions. And then there should be Sharia compliance. So the Sharia advisors in the Islamic financial institution will monitor the Sharia compliance. They will give resolution, they will give advice. At the same time, they will also monitor, and also they will get help from the Sharia audit and Sharia review in order to make sure that their Sharia resolutions are implemented, they are followed. Okay, so here to be clear, so Sharia audit and Sharia review, while Sharia audit mostly looking at the financial aspects of the Islamic transaction of Sharia compliant transactions and all the balance sheet, financial statements, while the review looking at the qualitative aspect of the Sharia, for example, the principle of contracts, al-bay, al-aqad, and also even the following the overall Sharia principles in marketing and others. So that is the Sharia review. So this is, I would say, the most recommended Sharia supervision model as proposed by the scholars. And I also do recommend that this should be the best model for Sharia supervision because the first important is the regulation. The regulation will make sure the management of the financial institutions, they are following what the Sharia advisors are giving resolution, so that the Sharia advisors, they will have a power. If not, if there's no regulation, so if the Sharia advisors role is just as consultants, just to give expert opinion, so that actually may create a lot of gap between the management and the Sharia supervisors. Okay, and usually this is how the Sharia committee or the Sharia supervisors, how they work in a Islamic financial institutions. Okay, there is a board of the directors. While as we know in the theory that the Sharia committee should be on top, okay, of all the boards, but in practice, we do not see. Usually the board of the directors, they are the highest authority, but the Sharia committee also work together with the board of the directors. Even our fee recommends that Sharia committee, they should work together with the board of the directors, especially the risk management committee. So there will be management, and in the management, there will be a Sharia risk management control function and Sharia audit function. So the audits will make sure, they will check on whether there is any Sharia violation in the transaction. And the risk management committee will, as we know, that the industry is moving towards from audit to risk-based approach, where actually the objective is we should stop the violation before it happens. So the risk management department, they will assess, they will measure whether there is any potential risk of violation of the Sharia. So the Sharia risk management department will give a signal, or they will give a red flag that there is going to be a violation. There is a non-Sharia compliance risk in this and this product. So that's the job of the Sharia risk management department. So they will ensure that they will find out, measure, and monitor the risk to stop the Sharia violation of the Sharia principles or the triggering of Sharia non-compliance cases before it happens. And at the same time, the Sharia audit will do audit, and they will report to the Sharia committee to make sure what their resolutions are implemented, it is practiced. Now there is a gap here, or question here, whether Sharia audit should report to the Sharia committee or to the board of the directors. Well, in different jurisdictions, they have different law. Some, they say Sharia audit should report to the Sharia committee, and the Sharia committee should be responsible for any violation of the Sharia. But some jurisdiction, they say no, Sharia audit should report to the board of the directors, and board of the directors are ultimately responsible for any violation of the Sharia principles. Like in the case of Malaysia, the Sharia audit, they should report to both board of the directors and the Sharia committee as well. And it's based on the meeting. If they have a meeting with the Sharia committee first, they will report to them. And if they have a meeting to the Sharia board of the directors first, they will report to them. So this is how it works. Or in some model, like in the case of like in Bangladesh, the Sharia audit will report to the Sharia committee, so that the Sharia committee will know whether there is any violation. So the problem arises when Sharia audit, they report to the board of the directors, and sometimes the board of the directors, they try to negotiate, or sometimes they compromise with the audit committee, and they hide if in the cases of Sharia non-compliance events, so which might be an issue in this case. However, again, who should, another important factor is who should be ultimately responsible for the violation of the Sharia principles. Well, as I said, there is most of the countries, they don't have that law. Okay, but in the case of Malaysia that I'll be showing is actually the management will be responsible, the board of the directors. And of course, the Sharia committee members, they are also responsible ethically, but there is no law so far that will penalize the Sharia committee members of an Islamic financial institution for if there is any violation of the Sharia principle. So I move on to discussing the roles and functions of the Sharia committee. Means Sharia committee, in the case of like in Malaysia, they call it the Sharia Supervisory Board in the respected financial institution. So generally, their role is to advise the board of the directors of the financial institutions on matters related to business. So first is advisory, is a consultation or expert opinion, and also to endorse the Sharia compliance manuals. Means every financial institutions are required to have a Sharia compliance manual. So this is a manual that will tell what is the procedures to get the Sharia opinion, and what is and then what are the steps to implement that, to disseminate that. So that is the Sharia compliance manual, and they should the Sharia committee should approve it, and they should also endorse and validate relevant documents, the terms and conditions of the products and documents, and to assist any related parties. So usually the product development department, they will work together with the Sharia scholars at the initial stage of developing any product to get opinion whether it is a Sharia compliant, and of course the final approval also should be from the Sharia advisors. And this is okay, their job. Usually at the end of the year, at the annual report, they will publish and they will sign. And generally, you can see in all the annual reports of the Islamic banks, they will have this kind of a letter from the Sharia advisors. They will say verify, they will test that all the activities of the company, of the financial institution, is based on Sharia, and if there is any violation, if there is non-halal income, it is purified, and the zakat calculation is made. So, and then there will be signed usually by the chairman of the Sharia committee or by all of them. So that's overall their job. And then there is also a responsibility of the Islamic financial institutions towards their Sharia advisors. So first, the Sharia advisors, they may not know all the issues, what is going on in the financial institution. So it is the job of the management to refer the Sharia issues to the Sharia committee. So that's why it is advised there should be a Sharia department in the bank, so that even the risk management department can bring the issues to the Sharia committee, so that they can give a resolution on that, and also and secondly, which is very important, to adopt the Sharia committee's advice. What the Sharia committee gives advice to adopt, and also to disseminate and to implement. And the Islamic financial institutions also to have a Sharia compliance manual, so that they follow the procedures to get the Sharia opinion, to implement it and the procedures. And it is also very important that the financial institution, they provide all the necessary documents, or whatever needed for the Sharia advisors to look if and they should facilitate, or what are the any sufficient resources if the Sharia advisors need to see physically to on certain issues. For example, if they have to do meeting and whatsoever, the financial institution should provide. And finally, of course, is the remuneration to the Sharia committee. This remuneration usually, as the AUFI recommends, it should be decided by the shareholders at the annual general meeting, so that the management does not have any influence on the Sharia committee members if the management, they decide on the remuneration. Now, so what should be the qualification of the Sharia committee or the Sharia advisors? As the name says, those who are the Sharia committee members, they should of course have knowledge in Sharia, especially on fiqh muamalat. Like in the case of the Malaysia, they also they know the local language because of the products, and they know Arabic and English because there are many product documents, mostly are in English, for example, and the majority of the numbers of the Sharia advisors should be Sharia scholars. However, there should have some scholars from finance and accounting background, because there are some issues related to finance that the Sharia scholars may not have understood, or they may overlook the issues related to that. So in order to maximize or in order to for the Sharia committee to be more effective, in order to find any issues in terms of accounting and finance, there should be one or two members who have background of finance and accounting, so that they can show to the Sharia scholars if there is any Sharia issue in any process or in financial transactions. So if that's the most one of the very important point here is to include someone with the expertise in accounting. And we have seen some Islamic financial institutions, they have used very big names, Sharia scholars, but then they have have some kind of products that is very controversial, but it is approved by all those big Sharia scholars. And so when we look deep into those issues, and it appears that in many cases, all those Sharia scholars, they were not aware of the issues related to that product. Means when the financial institution, they presented to the Sharia scholar, they did not present probably in a manner that the Sharia scholar could find the issue. So in order to stop that, we need to have someone which has a background in accounting and also finance. And the Sharia, according to the AOFI, recommends that the Sharia committee should meet with the audit committee and also the external auditor to review the financial statement. So as we know, the internal auditor, they are inside the management, so they may have the management can compromise with the internal auditor. So the Sharia committee, if they meet the external auditor, so they can get confirmation on whether there is any violation of the Sharia. Similarly, they can meet with the audit committee under the board of the directors they can see their reports on any violation. And number 3 is also so important on the disclosure of details of the activities of the Sharia committee. Means how many meetings, as I said before, that sometimes Islamic financial institutions, they use many big Sharia names, but many of them they do not join the meetings. So let's say there is one Sharia advisor, he is very famous, but he only sits one meeting in a year in that particular Islamic financial institution. So he may have missed many issues that raised in those meetings, and it is approved at the end of the year. So it is very important to disclose what the details activities were about their meetings, when they have done it, even also the choosing of the Sharia advisors, because when the Islamic financial institutions, they want to choose Sharia advisors with their proper procedures, because sometimes the financial institutions, they can know, in order to they can look for fatwa shopping, where they can look for which Sharia scholar is quite linear, quite flexible. So they look for him, they contact him and appoint him. So that can be also unfair, and also it can go against the best interest of the Sharia. So in order to make a proper procedures, it's better to have like an open advertisement and choose the best, and better it is appointed by an outside organizations. In the case of like Malaysia, it is appointed by the central bank. So that is better than it is appointed by the institution themselves, or they should be appointed by the shareholders at least. And then, so based on the issue in the C, okay, the number of attendance of the Sharia advisors is very important. And AOFI recommend, even the Malaysian Bank Negara said there should be 75% attendance, because this is amana, is a great responsibility. If the Sharia advisor misses even one meeting, so he may have missed certain issues that was raised in that meeting. But we cannot make it 100% based on the human nature. They may have medical reasons. So at least there should be 75% attendance. And the Sharia Advisory Council, they are an independent body, means that they should not be the full-time employee of the bank. They may be working as lecturers or researchers or whatsoever. So they have other jobs, so they will just maybe have meetings and they will oversee and monitor. Because if they work as a full-time employee, of course, there will be a lot of influence from the management for their decision making. So this the influence of the management is quite important issue. So all these principles are there to make sure that the management cannot make any undue influence on the Sharia advisors on their ijtihad, on their decision making, or while giving resolution on any Sharia matter. So now I will show you the legal position of the Sharia committee. As I said, so far as I know, the two countries, they put a very strict and stringent law for the financial institutions to follow the Sharia advisors' advice and the violations. So in the case of Malaysia, here based on the Islamic Financial Services Act 2013. So if there is any violation of the Sharia principle, if there is any case of Sharia non-compliance, immediately the financial institution should inform the Sharia advisor, and also they also need to take initiatives, or they should follow what the Sharia advisor give advices on that matter. If they do not do that, if there is a violation, the management will be penalized. There is imprisonment for a term of not exceeding 8 years, or a fine not exceeding 25 million ringgit, or both. And this is not only law, and this law also is implemented. Like recently, I have seen one of the Islamic bank was penalized with a few million ringgit because of not following the Sharia Sharia advisors opinion for violating the procedures in the Sharia governance. So they have there. So this is one of the law that gives the strength and that empowers the Sharia advisors to ensure that the Sharia, the Islamic financial institution, is following the principles of the Sharia. Now look at the issues and challenges in the Sharia supervision. One of the challenge is the differences of opinion. We call the ikhtilaful ulama, the differences of opinion. And as we know, ikhtilaful ulama is rahmah, is a blessing. But from looking at Islamic financial perspective, as in terms of governance and also looking at the market, we need some kind of unification, or we need to at least minimize the differences of opinion, because as we know that in order to make something as law, we need to have confirmation, we need to have certainty. If there is differences of opinion, so which one, who should be responsible for what, or if how to determine there is a violation. So we need certainty in order to make something as a law. And then also for in order to cater the interest, or also the market sentiment, is, as you know, in the case of like Malaysia and Middle East, there is always have two mazhab, or two opinions. So many Middle Eastern investors, they do not feel confident to buy sukuk issued by Malaysia, because they feel that they are not Sharia compliant, because they allow bay'ud-dain, or they allow BBA. So that's the issue when there are differences of opinion. So from the investor's perspective, no, they may be reluctant to invest to certain assets. So it is better to converse, especially on the main issues. But at the same time, also we know that it was not possible, and even the Sharia scholars, even in the past, they didn't agree to do that. Like even as we know from the tradition, like Imam Malik, he was advised to codify the Islamic law, but he didn't do that. He said there are different uruf, there are different customs among the people, and how can I make my opinion imposed on others? However, also we can see there was also attempt by the Ottoman Empire to codify the law. Like they have the Majalla al-Ahkam al-Adliyah, the Ottoman Majallah. So that was the way to codify the Islamic law, because as I said, when it comes to judgment in the law and judiciary, the law, it requires certainty. So of course, the Sharia law has different options, so we need to choose one for the sake of governance, for the sake of implementation. If not, it may lead to issues. In the case of Islamic finance, it will also lead to some kind of the investors, they will lose confidence on us. So we need to attempt to codify at least, and the way to solve this problem is through the National Sharia Advisory Council. So when there is a national body, if there is the differences of opinion among the one bank to another bank, then the National Sharia Advisory Council can look at it, and at least they can put a platform where they can discuss and come to a resolution. So as in this case, also we can see the AUFI as well as the Islamic Fiqh Academy, also they are having very good contribution to at the ummatic level. At the Islamic Fiqh Academy, they discuss some of the Islamic finance issues, and they give resolution, and which is also has a very importance to all the Islamic financial institutions. And then after that, the differences of scholars, another important factor is the fatwa shopping, which is also a major concern. And this fatwa shopping is just, is a process where the institution wants a Sharia certification, and it mostly happens for companies issuing Sukup, and also for in the country where there is no regulation by the central bank, where the following the Sharia or the Sharia supervision is based on the market force. Means they just need Sharia opinion in order to tell their customers or investors that this is certified by Sharia scholars. So in those cases, the fatwa shopping happens. So it is a process where the institution want a Sharia certification in the form of the fatwa of their transaction or practices, and ask different Sharia scholars for such a certification, and ultimately choose the one that is likely to give them the answer that they wanted. So it is a way that they already have something in mind, the product already have. So they look for, they contact the Sharia scholars, and which one allows this, so they appoint them as the Sharia advisor, and they get the job from him. So this is the fatwa shopping, which can be said in the context of Arabic is called talfiq, is something that cheating with the Sharia is breaching the trust. And here is an example which is reported by BBC News in 2009. So where it is reported, and it happened in a Western context, in a non-Muslim country, where there was no central regulation on following the Sharia. So look, so here what they said, that there are many financial institutions, they look for fatwa, they develop a product, and then they call. So look at this, I'm quoting at the second paragraph. We create the same type of products that we do for the conventional markets. We then phone up a Sharia scholar for a fatwa, seal of approval, confirming the product is Sharia compliant. And if he doesn't give it to us, we phone another scholar, offer him a sum of money for his services and ask him for a fatwa. We do this until we get Sharia compliance, then we are free to distribute the product as Islamic. So look, this is a concrete example of fatwa shopping, that they already have a product and they call different Sharia scholars, and whoever approves, then they give him money for service, and they allow it. So, and it happened in many Sukup cases, as I'm also going to show you. So that is the issue now, and this thing happens when there is no regulation and there's no central Sharia supervision. When there is a central Sharia supervision, when there is a central bank that regulates, gives procedures of how to appoint the Sharia supervisors, how to get the Sharia supervisors, what are the procedures to choose them and appoint them. When it is transparent, so this thing will not happen. And there are some other issues. Of course, there is a lack of jurists. As you know, Sharia supervision is not only to be familiar on Sharia matters, and it is also to understand the finance. And there are very few Sharia scholars who can really understand all those financial issues. And at the same time, they also well versed on the manuscripts, on the text. And even as we know, among the Sharia scholars, there is also specialization of fiqh muamalat, who understand the Sharia rules and principles related to muamalat. While there are many maybe on Quran or Hadith tafsir, but for this service, they should have scholars who are well versed, experts in the text related to financial transactions. At the same time, understand the financial transactions. And so there. So in order to get the jurists or competent jurists, so they need to have trainings of the Sharia advisors for them to get understanding. And also, of course, there are different ways now. The Sharia scholars also learning finance, and the finance people also learning Sharia. So that can create strong jurists. And also those who work in the Sharia department, who are the Sharia officers, when they further their study, they can also be very strong on these Sharia issues. Another important factor is the undue influence by the management. So if there is no proper regulation, it may happen that the management will have an influence on the Sharia advisors. Like recently, Malaysia has prohibited one Sharia scholar to sit for more than 9 years in a single Islamic financial institution. So that is a good move, because when one Sharia scholar is for very long, sitting for a long time in one financial institution, so they may have understanding, they may have a kind of undue influence. At the same time also, when one Sharia scholar is sitting for long in one Islamic financial institution, so he is also not allowing the newcomers, as we know that there is also issue that there is no new face in this Sharia supervision, and only a few names are repeated in many Islamic financial institutions. That is also an issue. And then in order to stop the fatwa shopping, they need to Sharia advisors proceedings. So the financial institution must disclose what are the way to appoint the Sharia advisors, and what are the procedures to get, and also whether the Sharia advisors, they join the meeting. There is at least 75% attendance. So this will ensure that there's no fatwa shopping. So here is the another issue is the appointment of a Sharia advisor on multiple institutions. Well, it is especially now in the Middle Eastern countries, where one Sharia advisor sits in many. So here there are many concerns. First is when a few Sharia scholars, they are sitting on many, so there is a barrier for the new generation to come in. And second is about the commitment, that how one person can commit on giving fatwa on so many banks. So as you know, it requires ijtihad, and ijtihad is something to make the best effort and to look into all the terms and conditions. In one terms and conditions of one Islamic financial product can be few hundred pages. So how can he go through all this, and he sits in many financial institutions? So that is a big concern. And the third is also it can give it can open the way for fatwa shopping, because when someone is famous Sharia scholar and the financial institutions already know his opinions, he allows this, he disallows this, so he is already famous for his opinion, and then he already give the similar opinion in one institution, so other institution find it very easy just to hire him, so that they can also get the similar opinion. So that's the issue related to when only a few Sharia scholars they are in the multiple institutions. And even just I heard that someone is sitting more than hundreds financial institutions. I didn't see, but just hearsay or rumors. And there was also research. It shows that only 8% of 8 or 10%, around 10% of the Sharia scholars, they occupy around more than 70% of the Sharia advisory board in a certain jurisdiction. So that was based on research. So in this case, in the case of Malaysia, they prohibited by the central bank that one Sharia advisor should sit only one Islamic bank and one takaful institution. So that's final, and they also cannot sit more than 9 years. And then, so here comes also the weak centralized supervision. While in Kuwait or in Qatar or even in Dubai, they have a central Sharia, but that Sharia is under the Ministry of Waqf and Islamic Affairs, and they're not fully concerned on the Islamic financial institutions. Rather, their concern is on all the Islamic affairs. And the Sharia advisors of the Islamic banks, they will only refer to them when there is an issue. Those central Sharia advisors, they not monitor, and so there is a weak supervision, and also there is a weak legal support in order to make sure the Islamic financial institutions are supervised well by the Sharia advisors of the respected banks. So there need to be a strong centralized supervision especially in the Middle Eastern countries. And that's similar to the absence of comprehensive regulatory framework. So along with the central Sharia supervision as a comprehensive regulatory framework, as I just showed in the case of like Malaysia, there is a law, and that empowers the Sharia supervisors, and then that also gives a proper procedures of the appointment of the Sharia supervisors, as well as how to avoid any undue influence. Like in the case of Malaysia, the Islamic financial institution cannot do anything to any Sharia advisors because they are appointed by the central bank. Even the central bank also cannot remove a Sharia advisors unless for two reasons. One reason is if he is absent from the meeting, and the second medical reason. So that actually empowers the Sharia advisors to give the opinion and to give the best opinion. And finally, the absence of the external audit. So Sharia advisors also should meet with the external auditor in order to know whether there is any violation, as the internal auditor may compromise with the management. So here is an example of Goldman Sachs Sukup controversy. Is a classical example of the fatwa shopping and also the violation of Sharia. So this Goldman Sachs issued 2 billion sukuk in 2011 based on Mudarabah concept. Okay, and so after that, a blogger, unknown blogger, he pointed out a few issues in that sukuk. Okay, and then that sukuk, when it is published in the prospectus, they wrote the name of some big Sharia scholars. It is approved by this and that. And then at that point, some Sharia scholars surprisingly found their names in the sukuk prospectus without their knowledge of the approval process. So how severe it is means the sukuk said this is approved by these big Sharia scholars, and these Sharia scholars, they don't even know anything about this sukuk, and this thing happened because there was no regulation. The Sharia supervision was just by market force, as I said, is just to get confidence of the investors, but there's no regulation. Because of that, this bank was able to get this kind of can publish these Sharia opinions, even though they didn't even get their approval from those Sharia scholars. And then finally, just I'll finish with this. There are some hidden traps in the Sharia decision making, like that the Sharia scholars need to be aware of, like the framing trap, where in many cases, the Islamic financial institution, when they present a certain Islamic product, they present in a way that everything is fine. They do not highlight the Sharia issues, and it happened like in the past, like in the case of as we know from Sheikh Muhammad Abdu, who is a famous scholar in Egypt, and he allowed conventional insurance because the person presented to him, he presented to him such a way that insurance is just like mudarabah, and he said it's okay, it is allowed. So it's also the framing trap is very important. The Islamic financial institution must be sincere to present the product in a way they need to, so that the Sharia scholars can know where is the gap and what are the issues. And the status quo and the anchoring trap, these are the trap quite similar, that people always have an emotion to give preference to the current state of affairs. Like, you know, the tawarruk is halal, so people already have a opinion or something feel good that okay, it is something halal. So if someone comes and he wants to say it is haram, he will find it difficult. Okay, so same with the anchoring tab, where some big Sharia scholars already said this is halal. So those who are the new Sharia scholars, they also find it difficult to, you know, to say that this is haram. And finally is the confirming evidence trap. So this is something related to the objectivity or honesty of the Sharia advisors. There are some Sharia advisors who they already have a hypothesis that they want to make this product halal, and then they look for the texts or evidences to make it halal or make it haram. So which is of course prohibited based on the principles of ijtihad, that jurist, he should not have you know, fixed opinion or a hypothesis earlier before, so it's may question his objectivity, and in that case, if he lacks the sincerity, he may also will be sinful for the even though he allows something and he knows that it is not Sharia compliant. So the Sharia scholars, they should not have a predetermined opinion and then he looks for the evidences to allow it. Rather, he should be free and then he look for the evidences. Based on the evidence, he will conclude. So that's all about the Sharia issues. I hope I touched the major issues, and there are many more issues, and the industry is moving forward. The conclusion is that we need more regulation, especially we need a central regulation and also cooperation from the financial institution and the government in order to improve the Sharia supervision. And also we need to develop the human capital. We need to create more Sharia advisors. So with that, I thank you. And if I welcome, if you have any questions, please.
Okay, thank you very much, Dr. Muhammad Farooq, for excellently elaborating the topic. And I hope, Alhamdulillah, you excellently touch all the major issues and challenges, and you elaborated the topic of Sharia supervisions by providing us some examples and models. I think that was really excellent presentation, mashallah. May Allah bless you, Dr. Farooq. Now we would like to welcome some questions if there are some questions from the audience. So please, you may write your questions and Dr. Farooq is there to respond to your question. Dr. Farooq, I think there are some questions.
Okay. Okay, let me see, go through the questions. Okay, in the Q&A, thank you. Which is it necessary for the Sharia Supervisory Board to approve the financial policies in order to be a guarantee that the is contents of any elements inconsistent with the principles and provisions of Islamic law? Is it necessary for the Sharia Supervisory Board to approve the financial policies to be a guarantee? Well, of course, it is necessary to have a Sharia supervision. It's not a guarantee. It goes back to the basic principle of a hisbah, as we know, that in Islamic Sharia there was always hisbah, check and balance. And as we know, Amru bil Ma'ruf and Nahi anil Munkar, and even during the time of Sayyidina Omar, he used to go and check whether people are doing the right thing in the market following the Sharia. So Sharia supervisors, firstly, they exist because of this concept of hisbah, that to monitor, to observe if there is a violation, they advise them. So that's the first principle. And the second, yes, there should be a Sharia supervisor, and they should work for the best interest of the shareholders and also the depositors, because they come to Islamic financial institution. They want to know that their investment is halal. So Sharia advisors, they have a fiduciary duty, or to make it from Islamic perspective, they have an amanah responsibility on behalf of the shareholders, on behalf of the depositors, to ensure that it is Sharia compliant along with the management. However, they cannot give 100% assurance. As I said, they will always say based on their findings. Even the audit, they also cannot give 100% assurance, because audit, they have to do sampling. They do not check each and every financial transactions. They do sampling, means they will check 10% randomly out of 100. They will check 10. So the audit also is not 100% assurance. So what I can say, it is based on what they're capable of. It is based on their best effort. And that's they say that based on what they know, that they guarantee that there is no violation of the Sharia. And if there is a violation, if there is, it is tackled, the issue, the non-halal income is purified. Yes, it is. It is, I would say, necessary, because from the market force and also from the Sharia perspective, because we human being, and especially the finance sectors, there might, as we know, we always have a clash between the economic man and the Islamic man. Not every time the Islamic man is powerful. the financial institution may sometimes violate the Sharia and they look for the economic gain. So in order to do that, we should have Sharia advisors, and not, as I said, it's not enough. We should have a double layer as well as with the regulation. Thank you.
Thank you, Dr. Farooq. I think there are two more questions.
Okay.
One more question.
There's another case. If there is a dispute between financial institution and customer, do Sharia advisors has legal backing and to settle the dispute, especially in Malaysia? Well, if there is any dispute between the customer and the bank, I'm not sure what will be the procedure, but in the case of Malaysia, if it is something related to the problem in the product, the Sharia issue, then of course the Sharia advisors, they will give a resolution, and there is a written resolution published by the National Sharia Advisory Council, Sharia Advisory Council of Bank Negara Malaysia. They already have a book where they already published their resolution, and if the matter is brought to the court, even the judge is also, it is mandatory for the judge to refer to those resolution. Yes, the resolution is there, so that resolution will be used to solve the problem. But if it is a personal matter, usually there will be arbitration. The customer and the bank, they will do something called suluh or arbitration to solve the problem. And in that case, maybe Islamic financial institution can take the opinion of the Sharia advisors. But if they cannot settle through arbitration, then the matter will be brought to the court, and the court, they will decide based on the National Sharia Advisory Council's fatwa or resolution. Okay, and I think that's all I know to answer your question. Yeah.
Thank you very much. Yes.
I think there's one final question. Maybe I can answer.
Yes.
When
last one, I think.
Yeah, so the question asks when there is an issue between the Sharia supervisor in a respected financial institution with the national Sharia supervisors. Of course, the national Sharia advisors' opinion is preferred. That's final. Even if in case, like let's say the national Sharia advisor says something halal, and the Sharia advisor at the institution, he said it is haram, and they need to discuss first. They need to negotiate with the national Sharia advisors. That is the regulation in Malaysia. But in the case of like Qatar and Kuwait, the Sharia advisor at the institution level, they are free to advise. In case there is a dispute, then they need to refer to the Sharia advisors in the Department of Ministry of Awqaf and Islamic Affairs. And whatever they give resolution is that is preferred. Okay, I think that's I have answered the question, so it's already.
Yes, Dr. Farooq, thank you so much for answering and for responding the questions. So we can see here two our brothers raised. I think one brother Muhammad Jidda, he raised hand. So let's allow him to talk. Brother
Okay.
Muhammad Jidda, please welcome, brother.
Well, good morning, Mr. Farooq. Thank you for the insightful presentation about the Sharia governance as well. My own is just a comment and realization that have been done since when I was in Malaysia. Looking at the current situation, we have a top Sharia scholars who are occupied by all the banks that, as you said, more than 80% or 70% are the well-known Sharia scholars are leading as advisors to many companies and consultation firms. So I think it's a high time for the young Sharia scholars to wake up and challenge these issues so they can key in, because every year we have a graduate from Sharia scholars background who are well knowledge with Islamic banking and finance, with the financial sector and everywhere. But it's very hard for them to get a chance to key in this such kind of banks or any company. So I think it is a very, very high time to we treat this challenge, and it can be done, and it should be done at the right time, because
Yeah.
I'm looking at what is happening now, coming back to my country, Nigeria, as well. We have the Sharia scholars who are, I think I can say, I put it in this way, they have a little background of the financial sector, banking and finance. They are Sharia scholars as well. But for them keen in such kind of environment is very difficult, because for you to even interpret or give them analysis on the banking and finance is a big deal. So we have the young Sharia scholars graduating from Sharia background, from Medina, from Islamic University in Jordan, all the in the Gulf and everywhere. So we need to give them the chance, and this is the right time. I think
Yes.
what Malaysia now currently is doing is a very fantastic thing. So I think the other countries should learn and look at what Malaysia is doing. You cannot stay on a boat for more than 9 years and only one Islamic finance. You will be an advisor. Also, the insurance, only one insurance company. That is a very well development. So I think this is my own point I want to make. And Jazakumullahu khairan. Thank you for the wonderful presentation.
Okay, thank you very much for your comment, brother. Yeah, so really it's a concern, and I hope the regulators in the, especially the Middle Eastern countries, they will come forward to this issue and maybe put a restriction on, sitting one person to a limited number of institution, and also limiting the tenure, maybe 10 years or 5 years. That should be the best move. And at the same time also, we need to improve the education system, so that we need to have a specialization that can create more Sharia scholars that have a background, or that they are expert, well versed in Sharia as well as finance, inshallah. So that will be the move forward and sustainable development for this field, inshallah.
Okay, thank you very much. Thank you, Mr. Muhammad Jiddah, for this wonderful comment. And we are almost concluding today's session. On behalf of Islamic Economics Association, Kuwait University, we would like to thank all the participants, online guests, for your participation and for joining us today. And as usual, every time, every week, in our English sessions and also Arabic sessions. So we thank you very much and for your support as well. And our thanks go to our management board, especially our staff and muhawirun and moderators, lecturers, professors, and especially our Director General, Dr. Alal Ubaid, for their wonderful job and for wonderful service for the Ummah and for promoting these Sharia standard models globally. And our special thanks go to our guest speaker, Mr. Dr. Muhammad Faruk Abdulla, for your time and effort. And may Allah subhanahu wa ta'ala reward you here and hereafter. Jazakallahu khairan wa
Iyakum.
barakallahu wa kataballahu ajrakum ya Dr. Farooq. So if you have any concluding remarks, please welcome Dr. Farooq.
Okay, thank you very much to Dr. Mahiuddin for again to moderating this session and inviting me for this lecture. I would like to thank Dr. Allah and also the Islamic Economic Association for arranging such a beautiful platform to share our knowledge around the world and also to thanks to all the participants for joining this session. It was really interactive session. I also enjoyed your comments and also your questions. Hope we'll meet again, inshallah. And may Allah subhanahu wa ta'ala make what the knowledge that we have shared, it is beneficial, and it is may we make it in practice, inshallah. And again, jazakumullahu khairan, nafa'allahu bi'ilmikum inshallah. Okay, with that, assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum assalam wa rahmatullahi wa barakatuh. Barakallahu feekum, Dr. Faruk, wa jazakumullah khairan. With that, we conclude today's session here. See you soon in our upcoming events and lectures, inshallah. Subhanakallahumma wa bihamdik. Ashhadu an la ilaha illa ant. Astaghfiruka wa atubu ilayk. Assalamu alaikum wa rahmatullahi wa barakatuh.
Alaikum assalam.
بسم الله الرحمن الرحيم. الحمد لله الذي رفع شأن العلم فأقسم بالقلم، خلق الإنسان من عدم فأمده بآلة الفهم، وامتن عليه فعلمه ما لم يكن يعلم.
نادي الاقتصاد الإسلامي بجامعة الكويت موئل العلماء ومنهل الفضلاء ومهوى أفئدة طلاب العلم الشرعي من كافة أرجاء العالم.
برامجنا لشهر يناير ثرية ومتنوعة، ما بين تأصيل وتنظير وتطبيق وتدريب وتعليم ومحاورة وتلاقح أفكار وتبادل تجارب.
مجالس العلم تبث فيها الحكمة وتغشاها الرحمة وتتنزل فيها السكينة وتحفها الملائكة.
حياكم الله، أحيوا العلم والأدب وانشروا العلم بين العجم والعرب. إخوتي، لا حياة لكم إلا بجامعة الكويت، فهي أما لطلاب العلا وأبا.
نستضيف كعهدكم بنا قامات علمية وأصحاب خبرة نوعية وباحثين ومدربين.
فهلموا يا رعاكم الله إلى مجالسه وأقبلوا على برامجه.
فقم بعلم ولا تطلب به بدلا، فالناس موتى وأهل العلم أحياء.
The programs and activities usually cover a wide range of areas in Islamic banking, microfinance, insurance, Islamic capital market, equity market.
فزينوا برامجنا بحضوركم ومتابعتكم، وأسعدونا بمشاركتكم ومداخلاتكم،
فإنها مجالس الخير والنفع والعلم ورياض الجنان. نسعد جدا بحضوركم ونتشرف بتواصلكم ونأمل دعمكم، ووفقنا وإياكم لنشر العلم ونفع الخلق ورفعة الإسلام والمسلمين.